Good evening, people. Good evening. I'm going to give you an update on the ex-sheriff of Clark County, Jamey Noel. He's the one that done the TV show 60 Days in Cooking. The good old boys of his party. Well, he went to court today. Hello, Anthony. And I'm going to share the video of him in court. You know, if you look at my glasses, they're red, white, and blue. You know, it's hard to see anything. I'm just fine, Anthony. So, but I'm just fine. I'm still PO about my Troy Belt rider since I ain't got the money to fix it. And
last name is Hoyt, H-O-Y-T, Richard Amanda, Common, 10, 27, 1980, looking for signatures.
so I'm going to present it to y'all using StreamYard. Let's see. I got to turn my scanner down. So
Set that matter for hearing here at 1:30 this afternoon. It's now 1:44. It's my understanding that the parties may have something of a resolution that they'd like to recite.
Yes, Your Honor.
Would you like to do so, Heather?
I can do that, Your Honor. Your Honor, we filed a motion to intervene to address property that belongs to my client that is currently in the possession of our staff. Go check out the 18 vehicles that belong to my client. They're in their possession. Just make sure they're running, they're in good order. And then we're also going to work with the state police to find a storage unit that would be accessible only to ISP to maintain the care, custody, control of the vehicles, but yet be undercover instead of right now we're currently in an ISP lot that's chain link. It's their car has special car covers on them, but they're still outside exposed to the elements should the car covers come out. So I think that we can work on a resolution within the next 90 days, and then I would withdraw our motion after that period of time, Your Honor.
In the interim, you will not be getting access to anything that may be sealed,
No, Your
no
Honor.
prior notice of the search warrants.
No, Your Honor.
You gonna go get the refrigerator?
And the prosecutor and the Attorney General's office say we could do so. I'm sure that Chief Owen would make some kind of effort to go out there and get those.
Mr. Hurdle?
Thank you, Your Honor. I think Ms. Peters accurately described the agreement between the state and UDIC at this point in time. The state's not prepared to concede that they should be allowed to intervene, nor should there be a return of property at this point in time, but we're not going to get into the merits of the case as Ms. Peters suggested, and we're just going to ask this be moved approximately 90 days for some potential negotiation, as well as allowing them to review the property under the guidance and I guess supervision of the Indiana State Police. And at this point in time, we're not prepared to return anything at this point in time as it's potential evidence of criminal conduct.
Understand. And I assume you understand that also.
Yes, Your Honor. We work pretty closely with the state police and the state board of accounts throughout this process. We understand.
Have any use for an $800 belt and a bunch of suits?
No, I don't think so.
Anything else?
No, Your Honor.
I think that's all, Your Honor.
All right.
Thank you, Your
Would
Honor.
you be so kind to prepare the entry for
I will,
today
Your
and send it to Mr. Hurdle for
Yes,
review and sign off on?
I will do so.
All right, we'll be off record unless there's anything else that needs to be addressed in this matter.
No, no.
Not from the state, Your Honor.
And it's my understanding the parties would like about a 5-minute break before we start the next hearing.
Yes, Judge.
All right, we'll be off record.
Thank you, Your Honor.
We'll be back in about 5.
We didn't know you were finished.
We just got back.
Okay.
I guess I can go with the judge. Hey, Lori, I think we're ready.
Okay.
Okay.
All right.
Welcome back. Thank you. All right, cause number 10, C01-2311 F5297, State of Indiana versus Jamey. Noel. Mr. Noel, this is your initial hearing on 6 new criminal charges. For the record, would you state your full name
Jamey John Noel,
and your date of birth?
12/18/70,
That'd make you how old?
53,
And last 4 digits of your social security number.
2558, Your Honor,
What's your address?
3001 Old Tay Bridge, Jeffersonville, Indiana, 47130.
And are you under the influence of any drugs, including alcohol today?
No, Your Honor.
Read and understand the English language?
Yes, Your Honor.
If I say something you don't understand, will you let me know?
Yes, Your Honor.
I'll go through these counts.
Judge, before
Yes.
we go into the initial hearing, I just want to, for the record, I want to note an objection based on the statute relative to amended information, specifically under subsection B2. I believe we're past the omnibus date. I think it's clear that the charges are additional counts, some of which alter defenses and or evidence that might be adduced at trial. So I think it's clear that they tend to affect the substantial rights of the defendant. In that case, I just want to note that we believe that under subsection D, we should have been permitted adequate notice and an opportunity to be heard prior to the court entering an order on June 3rd accepting the charges. But I understand the court has set this for an initial hearing, and I just want to note that.
State like to respond?
Well, a couple things, Your Honor. I guess first of all is there is a provision within the statute that allows for the amendment or the additional charges to be filed based on newly discovered evidence. As the court knows, and certainly the defense knows, this is an investigation that has basically continued on since probably June or July of last year, so almost 12 months of continued investigation. And many of these things were recently brought to light through search warrants through American Express, Sam's Club, and a number of other entities. So that newly discovered evidence allows for the additional evidence. Further, the state would show that we're not set for trial until November. This certainly gives the defense ample time to review the new additional charges, the newly discovered evidence, and time to prepare for a trial in November, which is 5-ish months away from now.
Mr. Stewart, anything you'd like to say in response?
No, Judge, I just want to note that the normal remedy would be if done close to a trial. I do understand the normal remedy would be a continuance of that trial date. We're not saying that it's impossible for us to prepare at this time. It's hard to know depending on what may be turned over in the near future. But again, I think under that subsection D, despite I'm not exactly clear where it says there's a basis that's solely about new evidence. I mean, there is a procedure to follow in every amended information, and subsection D provides that the defendant is entitled to adequate notice and opportunity prior to the setting of an initial hearing on that, and basically to address these types of issues. So,
Well, and that
nothing
may be
further.
partly the court's issue, Mr. Stewart, just in the interest of a judicial economy. Everybody was available and could get it done today. So you have a formal objection, feel free to file it. If you need additional time to prepare for trial, I'm not opposed to granting that. Might want to talk to your client, see if there's anything else that may be discovered.
Thank you, Judge.
All right, count 26. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44.1-2-1 that between June the 4th, 2019 and August the 21st, 2023, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally acquire or maintain an interest in, receive, conceal, possess, transfer, or transport the proceeds of criminal activity and or conduct, supervise, or facilitate a transition involving the proceeds of criminal activity, and or invest, expend, receive, or offer to invest, expend, or receive the proceeds of criminal activity or funds that are the proceeds or funds of criminal activity, and the person knows the proceeds or funds are the results of criminal activity, and said proceeds or funds have the value of at least $50,000. It's a level 5 felony. Count 27. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44.1-2-1 that between June the 26th, 2019 and December the 31st, 2022 in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Clark County Sheriff's Department with the intent to deprive said entity of any part of its use or value of the property, said property having a value in excess of $50,000. That be December the 31st, 2019, 5 lawnmowers in the amount of $18,651.65, and or July the 20th, 2022, HVAC system in the amount of $6,539.12, and or June 26th, 2019, a Dodge Ram in the amount of $11,000, and or December of 2022, shipping containers in excess of $25,000. Count 28. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44.1-2-1, that between March the 31st, 2020, and November the 29th, 2021, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of the use or value of the property, and the property having a value in excess of $50,000, that being child support payments in the amount of $50,968. Count 29. I, the undersigned, and these are all signed by Richard J. Hurdle. I, the undersigned, do hereby affirm, under the penalties for perjury, as specified in Indiana Code 35-44.1-2-1, that between December the 2nd, 2019, and January 21st, 2023, in Washington County, Clark County, state of Indiana, habit, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of its use or its value of the property, and property having a value in excess of $50,000. That being January 21st, 2023, a BMW in the amount of $21,000, and or May 1st, 2022, a 1957 Chevrolet in the amount of $40,000, and or August the 13th, 2022, a 1966 Pontiac in the amount of $33,919, and or January the 6th, 2020, a 1979 Pontiac in the amount of $20,000, and or December the 2nd in the amount of $52,500, and or May the 20th, 2020, a 1970 Dodge in the amount of $45,000, and or July the 28th, 2020, a 1959 Corvette in the amount of $45,000. Count 30, theft, 11.5 felony. I, the undersigned, do hereby affirm under the penalties for perjury or specified in Indiana Code 35-44.1-2-1, that between February the 17th, 2022, and May the 10th, 2023, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of the use or value of the property, and the property having a value of at least $50,000, that being May the 10th, 2023, an HVAC system at the Turnberry Mansion in the amount of $2,700, and or March the 22nd, 2023, chimney repair at the Turnberry Mansion in the amount of $11,200, and or February the 17th, 2022, airplane purchase in the amount of $25,000, and or September the 9th, 2022, airplane repair in the amount of $16,616.63, and or July the 13th, 2022, a Cub Cadet mower purchase in the amount of $11,000. Count 31. I, the undersigned, do hereby affirm under the penalties for perjury as specified in Indiana Code 35-44.1-2-1, that between November the 9th, 2023, and March the 29th, 2024, in Clark County, state of Indiana, Jamey Noel did knowingly or intentionally exert unauthorized control over the property of Utica Township Volunteer Firefighters Association with the intent to deprive said entity of any part of the use or value of the property, and said property having a value in excess of $50,000. That being American Express credit card purchases in the amount of $37,151.40, and or Sam's Club credit card purchases in the amount of $15,667.16. These are all level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. You understand what you've been charged with?
Yes, Your Honor.
And you understand the potential penalties?
Yes, Your Honor.
My next question is usually, do you intend to hire a lawyer? But you've got a stable of lawyers, so I assume you intend to enter a not guilty plea, Mr. Wilder.
Yeah, Your Honor, at this time, Mr. Noel, how do we wish to enter our plea in this matter?
Not guilty, Your Honor.
Thank you, Judge.
I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, see, hear, question, or cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf, and at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf and bring evidence. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone. You do have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be used against you. Do you have any questions concerning your rights?
No, Your Honor.
All right. Enter the not guilty plea on your behalf.
Thank you, Judge.
Now, state of Indiana, with the issue regarding bond.
Yes, Your Honor. Given this matter is in the same cause number, the state believes that the appropriate statute for the court to consider is 3533.85, alteration or revocation of bail. And the state is asking for the court to alter his bail today. I think a couple of factors that the court should consider in determining whether or not to alter the defendant's bail today is that back in November, when we initially filed these charges and he had his initial hearing, many of these things were not known to the state at that time. Had the state known about these things, we probably would have charged at that point in time and probably would have affected the bail either request by the state of Indiana or the bail set by the court at that point in time. So many of the things that have now been charged, either back with the 10 counts and now with these 6 counts, were not known at the time. So I'd ask the court to consider that. I'd ask the court to consider also back at that November hearing, when the same day that the initial hearing was, the defendant posted his bail that day. And part of his requirements that he not commit any new additional crimes. And if we look at the statute a little closer, bail can be altered, potentially even revoked, based on the commission of a misdemeanor or another crime. We have alleged through the state that he has committed 6 felonies. Probably the key one of those is count 31, which is the theft. And the theft that encompasses is what happened after the November 9th hearing to March 17th and March 29th. Because at that time, in that 3 or so months time span, maybe 4 months, the defendant is alleged to have used the credit card, American Express, as well as the Sam's Club credit card, both owned, operated by the Utica Volunteer Fire Department. So in excess of $50,000, approximately $52,000 was charged on those 2 credit cards as alleged in count 31. Commission of a new criminal offense can alter a defendant's bond, or at least the court can consider that. That combined with the contempt that the defendant had approximately 50 or so days ago, when there was blatant disregard for the court's order to remove all weapons, the court obviously took that into consideration. But the use of these other credit cards is furthering this whole same entitlement, greed, lack of basically disdain for the court's authority. And so that's what the state believes is key in altering his bond today. And the state would ask you to alter his bond. So these additional crimes post-arrest are the key factors, and the other 5 counts also were not completely known at the time back in November when he was charged. So based on these factors, based on the statute set forth, and primarily, Your Honor, the 41-page probable cause affidavit outlined by Detective Herron, the state would ask the court to take judicial notice of that, filed in this cause number.
Court will do so.
I'm sorry?
Court will do so.
Thank you, Judge. That is the evidence that the court needs to alter his bail. And the amount, the state requested a $25,000 bond at the initial hearing, and the court saw fit to set bail at $75,000. Based on his actions since November, the state believes that it certainly needs to be elevated at the court's discretion, but certainly a significant amount higher. Thank you, Judge.
Thank you, Mr. Hurdle. Mr. Stewart or Mr. Wilder?
Judge, I think again, I just want to note that the specific requirements and alteration of bail, similar to the requirements to modify or amend a charge, required adequate notice and opportunity. I mean, Vasendak, which is the case that prosecutors cite to hold people without bail until that hearing can be held, they have to specifically outline which pieces of the Indiana Code that we are alleging to have violated under the bail statute. Under Indiana, and I agree that we are under the exact code that Mr. Hurdle recited, but we're citing to specific sections that deal with alterations to increase bail, and then a separate section dealing with specifically outlined pieces relative to full revocations of bail. So I think that they're mixing 2 different pieces, and that's problematic because there's a different standard of proof that is specifically outlined in the revocation pieces of the statute, and it's clear and convincing evidence. And a probable cause affidavit, despite the fact that the court may agree that there's probable cause, that is a very low standard in comparison to clear and convincing evidence. So, I mean, that's the standard we use to take people's children away, not the standard that we use to, again, without notice, revoke somebody's bail. When you look specifically at the sections of the statute that deal with applications to the court for modifications for increase, what it notates is that if they present substantial evidence that indicates he is of a high risk to not appear for court, or if they present additional evidence relative to new charges, and that evidence, I mean, it specifically specifies DNA evidence, those are the times when you can increase bail. And I think that this process of trickling charges every couple of weeks or months, it sets a bad precedent, and it's bad policy to allow that to occur, because at this point, any prosecutor in the state of Indiana can file initial charges, wait a little bit, see if they like what the court's order is on bail, potentially defendant posts, file new charges that they knew of, and there are pieces of this that the prosecutor has known since prior to the First Amendment. So, and again, I do think that count 31 relative to the issues, is something that the court could consider, but it's an evidence-based process, and the standard is laid out for revoking based on a felony charge, and it's clear and convincing evidence that happened. So I would just I'd ask that the court take judicial notice of the IRAS assessment that was done at the initial hearing. I don't believe any of the information contained inside that document has changed. Mr. Noel's ability and desire to show up for court has not changed. And there's been no evidence presented to the contrary. Thank you.
Thank you, Mr. Sheriff. Question for anybody. Does Mr. Noel still have access to the Utica Township credit card?
No, Your Honor.
He hasn't for a lengthy period of time, Judge.
I'm sorry.
He has not for a lengthy period of time had access to the credit card.
Your Honor, my client cannot confirm, we cannot get any,
This,
Judge,
Ms.
I'm-
Peters has no standing.
he said anybody who wanted to answer, I'm trying to answer.
Your Honor, I do not believe that at any point the court says anybody who wants to answer includes anybody sitting around that may or may not have a law degree.
All right. And I agree with that.
Thank you, Judge.
I'd like to call you as a court's witness. You solemnly swear or affirm under the penalties of perjury, testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
For the record, tell me your name and your position.
Heather Peters, I'm General Counsel for Duty Chapel.
And I asked a question. The counsel out there, I guess not for the general public.
Sorry, Your
It's all right. You have a responsibility to your client in regards to whether Mr. Noel still has access to those credit cards. Can you enlighten me?
Your Honor, as to the American Express card, we did receive a notice in the mail from American Express that that account had been closed due to fraud, that there was a balance on it. We have not been able to receive any other information regarding that account. The Synchrony Bank, we have never had access to. Our chief, on my direction, had called Synchrony several times. We could not get information. That's why we filed a declaratory judgment action in Floyd, I guess it's in Clark County, but it's being heard by Floyd County Judge. So we have not been able to ascertain if that account's open, if there is balance on it, and who has cards. I believe that Lieutenant Aaron at some point did get a copy of a card that was Misty's maybe. I don't know if he has a physical card or not,
Judge,
so we can't look at.
The one problem I have at this point is that Ms. Peters, who should know the rules of court, is turning to people and basically asking them to give her answers
Yeah,
while
I'm
she's
not asking them to
testifying.
give me answers. I'm just acknowledging.
Yeah, trying to confirm.
You know, you can't
Yes, sir.
ask anybody else to help you.
Yeah, sure.
Has Mr. Noel used those cards lately?
Not to my knowledge. I did have a conversation with Chief Owen, and he has not seen any, and our accountant, he has not seen any charges come through in the last 2 months.
Counsel like to inquire.
Just a couple questions,
You
Judge.
may, you may.
So ma'am, the Amex card we're talking about,
Yes, Your Honor. Or yes,
No.
Mr. Wilder.
never will that ever be something anyone will get to say.
He hasn't got elected yet.
I will never run. Mark it down. So, the Amex account we're talking about, you're familiar with.
Yes,
And the Amex account we're talking about had cards issued to other individuals whose last names were not Noel, correct?
that,
Correct?
I have to think, yes.
And one of the individuals was a fellow whose last name was Wilkerson, right?
Correct.
And it's already been determined and established through the State Board of Accounts audit that Mr. Wilkerson's credit card was used in a manner which was not consistent with the law, right?
I don't know that that was the exact wording of the State Board of
The
Accounts.
State Board of Accounts determined that there was $40,000 spent on talking about,
Correct.
right?
Correct.
And in addition to Mr. Wilkerson, there were other individuals who had Amex cards, correct?
Correct.
Mr. Owen had an Amex card, right?
Correct.
There are other folks whose names are on and who possess Amex cards that have the ability to use those right up until that account was closed, right?
Correct.
We don't see an itemization in this new charge of whom used this credit card and made what charges, did we?
In the information, I didn't review the information as I thought.
We
I've seen the
don't,
credit card statements though.
we don't know who used the card during this time frame and how much they charge, do
I know from looking at the statement, yes.
we
It's our
agree?
issues.
My question is simple. Of this $53,000 that is alleged that was spent, the Amex portion of that is whatever, because it's gone away on my screen. We do not know whether or not, based on the charge, those charges were made on a credit card of Mr. Knowles, do we?
I can't say that if you're asking based on information, because I haven't seen the information.
Synchronicity. What is it?
Synchrony.
Synchrony. Synchronicity is what we should all be experiencing, right? Synchrony. There were other cards issued to other folks from that account, wasn't there?
Yes,
So Mr. Knowles not the only individual who had access to a card, right?
not on the Synchrony account.
Mr. Eubanks had a card.
I don't know.
Mr. Wilkerson also had a card.
I don't know that.
Mr. Owen had a card.
Yes, I haven't had a card.
So other people had a card, and that charge doesn't reflect whether or not the charge that Mr. Noel is facing, whether or not the number presented is just charges that are alleged he made, right?
I can't say that. I haven't seen the information. I just know what Judge Medlock read of his account.
And we also know and agree that the American Express account was in fact guaranteed by Mr. Noel personally, correct?
That's my understanding, yes.
So had anyone defaulted on the American Express card, Mr. Noel would have personally been responsible for paying it, right?
In addition to my client, whose EIN was also listed on the account.
I've got no further questions, Judge. Thank you.
Mr. Hurdle,
No questions.
Mr. Eubanks had a card?
Mr. Eubanks, I don't know,
Well, Mr. Wilder said Mr. Eubanks had a card.
and I don't know that. I don't know if he had a Synchrony bank.
I'm looking forward to getting acquainted with Mr. Eubanks. Court has no further questions.
Thank you.
Thank you, Ms. Peters.
Anything else from anybody? Mr. Stewart?
I would just go back to, I think, the court's initial question of Ms. Peters, that she has no evidence one way or another. And the state has not presented any additional evidence relative to a high risk for non-appearance. Or specifically DNA evidence tending to prove that the defendant committed some type of new charge that they did not know about at the time of filing of the initial information. And for those reasons, the specific subsection dealing with bail increases, those are the reasons. So thank you, Judge.
Anything else, Mr. Hurdle?
Only briefly, Your Honor, with respect to the American Express card and who used it, who had it, while Ms. Peters may represent Utica, the criminal investigation conducted by the Indiana State Police, specifically Detective Herron, she's not privy to that investigation. Who used what card when, and as page 7 of the probable cause affidavit denotes, there's a credit card number with a specific name of Casey Noel, Utica Township Fire Department listed on that. Had there been evidence that Casey Noel was continuing to use that credit card, there may have been additional charges on her. However, the allegation is that the defendant, Jamey Noel, in this cause is the one who has used that. Ms. Peters may not know exactly what the investigation entails, so I would ask the court to just to consider that as it's making its determination of who had which credit card and who was charging it. The allegations that the defendant was using it with his card.
Thank you, Mr. Stewart, anything else?
I think again, just Judge, it's an allegation at this point, and it's information tending to demonstrate probable cause. Just an entirely different standard than the one that the court is required to consider for full revocations. Now, as to modifications or alterations, increases of bail, again, similar circumstance where the probable cause is not the standard. So.
Stuart, I want you to know I have the greatest respect for your legal knowledge and your knowledge of procedure. You're an intelligent man. I'm going to reiterate this again. I told Mr. Noel not to deceive me, not to define me. He would not like the consequences. Didn't seem like you listened the first time. You released, and thus I sentence you to 60 days for contempt. Your behavior since you were released seems to fit into all these categories. You know, I'm just a country boy from Washington County with a public school education. But when somebody warns me not to do something, I try to heed that warning because we say what we mean up there. So this is my analysis. With the informations and the affidavits that were filed, it appears that you had, or at least did have, an airplane, a train that was hidden, a stable of exotic motor vehicles, a harem of women, at least 3 mansions, and set that matter for hearing here at 1:30 this afternoon. -44.1-2-1.
I can't say that if you're asking based on the information, because I haven't seen that information.
Increases, like, again, similar circumstance where the probable cause is not distinct. So.
And thus I sentence you to 60 days for contempt. Your behavior since you were released seems to fit into all these categories. You know, I'm just a country boy from Washington County with a public school education. But when somebody warns me not to do something, I try to heed that warning because we say what we mean up there. So this is my analysis. With the informations and the affidavits that were filed, it appears that you had, or at least did have, an airplane, a train that was hidden, a stable of exotic motor vehicles, a harem of women, at least 3 mansions, at least $3,000 suits, $800 belts, which you get personally delivered. And still seem to think that the Utica Volunteer Fire Department's your personal piggy bank. All the while, every day, individuals are trying to survive, working paycheck to paycheck. with their own money that they've worked hard for while you're out flaunting the luxuries acquired allegedly at the expense of taxpayers. So with all these luxuries and all the money that you've allegedly taken, I'm thinking about $1.5 million in bond ought to be appropriate. You should be able to post that with no problems with everything that you have. If you don't listen to that, you post it, I don't know where we're going.
Does that increase by 1.5 million or is it a total of 1.5?
Oh, do you have that much in the bank of water?
Judge, I was just trying to figure out my math over here.
We'll make it 1.5 even.
Thank you, Judge.
Shall we hold it until you go get it?
I would say Mrs. Wilder probably would have questions about that. Thank you, Judge.
Is there anything else?
Nothing from the
Mr. Stewart? I may be wrong, but my responsibility is to the citizens of Clark County, the state of Indiana. And I think this is what must be done in order to continue to protect their interests and restore their faith in the rule of law. So
Thank you.
that's my word.
Nothing from the state, Your Honor. Thank you.
I'll be off.